I find that distressing and antithetical to his conduct since he has been a prisoner. And I know that you have a letter from Mr. Timothy Savoy on behalf of the family, but I can tell you that the trauma continues to this day. And no one has been able, they couldn't even get Ms. Lejeune to come to this because it is so distressing and so traumatic. So again, I compliment Justin Singleton. I'm in awe of his accomplishments. He hasn't done the first step. Last hearing I was here, last time I was here, when one of the board members says, the first step necessary is to acknowledge guilt.
That's the first I've heard it.
I'm sorry, not in this
First
case.
time I ever heard that.
And that's the feisty Keith Jones. That's not the first time that I have seen him jump in and tackle an ADA. He likes to fight like that. It's quite interesting. Now this is a commutation hearing that took place back in 2020. He has been serving a life sentence since the age of 23. He's been in for 17 and a half years, but claiming his innocence, still showing up at his commutation hearing to claim that he was wrongfully convicted. We have seen people take this approach a few times, and it always does beg to question, is he actually innocent? Well, we're going to hear from the district attorney that prosecuted this case. We already did, but he has a pretty powerful mic drop. And we're going to hear from others in this case. And I'll unpack it with the details of his appeal at the end. Now, remember, this is only for a commutation hearing to recommend to the governor to give him a chance at parole. But with that, let's jump in.
You are Justin C. Singleton. Your DOC number is 509796. You were sentenced on May 26, 2006 to life for a second-degree murder conviction. Is that information correct, Mr. Singleton?
Yes, ma'am.
Okay, thank you. Mr. Roche?
Good afternoon again, Mr. Singleton. How are you?
I'm doing well, sir. How are you?
Good. I have a presentation prepared. At any time the information is not correct, would you interrupt me and correct me, please?
Yes, sir.
Madam Chairman, good afternoon. Before us this afternoon, we have Justin Charles Singleton, DOC number 509796. He's here this afternoon seeking a recommendation for a commutation of sentence for the offense of second-degree murder. He's currently 41 years old. At the time of the offense, he was 23. He's been incarcerated for the last 17 and a half years. On Mardi Gras Day, 2003, Mr. Singleton, along with his co-defendant, Joseph Patrick Guillory, was arrested, charged, and later convicted of murdering Mr. Kersey Lejeune, the owner of Lejeune's grocery store in Mallard, Louisiana. On April 30th, 2003, the St. Landry Parish Grand Jury filed a true bill of indictment for first-degree murder of Mr. Kersey Lejeune against Mr. Singleton and Mr. Guillory. On December 17th, 2004, Justin Charles Singleton was found guilty by a jury of his peers of a reduced charge of second-degree murder. And on May 26, 2006, approximately 18 months after he was found guilty, he was sentenced to serve life imprisonment at hard labor without benefit of probation, parole, or suspension in sentence. A month after his trial, Mr. Guillory went on trial in January of 2005, and he was also found guilty of second-degree murder. And is serving a life sentence at this time. The opposition in this case comes from the DA's office of St. Landry Parish, the Sheriff's Office of St. Landry Parish, the judge of the 27th JDC had no comments. Opposition also comes from the victim's wife through his cousin, Timothy Lejeune, and Mr. Lejeune says Mrs. Lejeune is opposed to any clemency in this case. There is no supervision history in this case. Mr. Singleton has never been on probation or parole. He has only 2 arrests on his record. His first arrest was in September of 1998. He was charged with simple burglary. This charge was now processed because of witness misidentification. He was not the subject of that simple burglary. And the second one, of course, is this offense that he's applying for a commutation of sentence for. He has a very low risk assessment score, along with a very low needs score on the Tiger. His present job, he is a certified vocational tutorer. He has good family support. He is in minimum custody. He is the lead mentor in the reentry program at Louisiana State Penitentiary. And he is considered to be an expert outdoor motor technician. If there's a motor attached to equipment that you use on the outdoors, whether it be 2-stroke, 4-stroke, diesel, Mr. Singleton can work on those engines. As I said before, he's a lead mentor in the reentry program. He's also the safety coordinator for the reentry program. While working in this program, Mr. Singleton saw a need for safety in this area. He actually drew up the proposal, submitted it to the officials at Louisiana State Penitentiary. They accepted his proposal and appointed him the safety coordinator. Programs that he's completed: Thinking for a Change, 100 hours pre-release, personal development, problem solving, anger management, employment skills, victim awareness, money management, Raise Your Cage, Inside Out Dad, just the gamut of the basic good time courses. Mr. Singleton, would you like to add any other good time courses to that list?
Yes, sir. I have completed an assortment of other courses as far as well as discipleship classes, JCs.
So I mean, good time. I'll get to those later.
Oh, okay. No, sir.
Okay. Mr. Singleton has a very good institutional record. He is a Class A trustee. How long have you been a Class A trustee?
Since August 15, 2013.
So we're talking 7 years.
Yes, sir.
Okay. He has an approved residency plan in Baton Rouge, Louisiana on Terrace Avenue, and he has employment secured with Vote. He'll be working out the Baton Rouge office. He has only one disciplinary write-up in 17 and a half years of incarceration. That was in 2010 when Mr. Singleton had a visitor at Angola and he either wanted or needed a new pair of shoes. With the consent of the visitor, they swapped shoes, and that was against the rules, and he received the write-up of number 22. In 17 and a half years, he's not had one violent, one criminal, or one aggravated offense on his record. His classification officer stated, and I quote, "Offender is well-mannered, respectful, and meets all expectations. Work supervisor," and I quote, "a great work ethic." And the security supervisor stated, and I quote, "a Class A trustee, no threat to security at any time." Bear with me. This young man has been busy the last 17 and a half years, and I'm going to try to go over some of his achievements. I can't mention them all, but I'm going to start with a list on page 155 of the PPI, his educational achievements. I'm going to stop there and ask Warden Bernard, does he have any comments, remarks, observations?
Hello, Mr. Roche. I don't like to go behind you, Mr. Roche. Again, you did a very thorough job. Justin, during his time here, has done an excellent job. You know, his conduct record is exemplary. His work ethic is good. He's well respected. He does an excellent job as a reentry mentor. And, you know, you said what could be said, all his accomplishments here. There's really no other self-help programs that we could offer him. He's done a great job.
Thank you, Warden Bernard. And Madam Chairman, if you would give me at least 2.5 minutes more, I would like to summarize Mr. Singleton's incarceration. He was arrested 17 and a half years ago. He was at the St. Landry Parish Jail where there was no programs, but he saw a need that there were many illiterate offenders in jail with him. So unofficially, he took it upon himself to tutor those individuals. And between the time he was arrested and convicted, it was 3 years. And when he left, most of those illiterate offenders could read and write. Upon entering the gates of Louisiana State Penitentiary, he was assigned to the field. He was a field hand. And it's hot or either cold, and he worked in the field for 3 or 4 months and had no disciplinary write-ups. He was transferred to Camp F, and everybody knows where Camp F is and who is the inhabitants of Camp F. The
Camp
disciplinary problem.
MJ.
J, I'm sorry.
That's okay.
Camp, yeah, Camp J. And everyone knows what at Camp J. Disciplinary problems, people who cause chaos in the institution. And he was assigned as a dormitory orderly. And for 3 years while at Camp J, he did not have a write-up. Instead, he concentrated on his religious aspect of his life. After 3 years, he was transferred to the main prison. When he was transferred to the main prison, he immediately started taking good time classes and involved himself in bettering his education. He was a second semester freshman at the time of his arrest, and he went about the business of completing his education. And that summarizes Mr. Singleton's incarceration. And Madam Chairman, I do have a recommendation in this case, and I will share it with my fellow board members at the conclusion of this interview.
Thank you, Mr. Roche. Mr. Marabella?
I have no questions. I'll just listen to everyone else.
Okay, thank you. Mr. Wise?
I don't have no question.
Mr. Jones?
I would take this occasion just to say hello to Mr. Taylor, who I haven't seen in probably 40 years. Ever since he stopped going on trial lawyer trips and went straight and ran for DA. And we may be chatting later, Mr. Taylor, about your opposition once we hear from you. But Mr. Singleton, Mr. Roche has always did an excellent job of presenting the case, and so I have no questions, not yet.
Okay, thank you. Thank you, Mr. Jones. So at this time, we'd like to hear from Ms. Garrett, the fiance.
Good afternoon.
Good afternoon.
How are you? First off, I'd like to take this time to acknowledge the many family and friends that are supporting us today that are currently watching on YouTube. We have no doubt that those same individuals would definitely be here in front of you if the conditions were applicable for that. I have with me Justin Singleton's mother, as well as my own family here in complete support of that. I want to start off by saying that, you know, I've known Justin's family for a little over 15 years now. I've grown to know about him over those years, and I know the family upbringing, and I've actually met Justin 5 years ago. And my life has never been the same since I've met Justin, just to be perfectly honest with you. I've seen him, as well as his mother, have seen numerous individuals approach us during visits, just declaring how much of an impact and influential person Justin has been in their lives, in their loved ones' lives. She actually brought a card that was signed by an entire camp that was mailed to her, just showing gratitude for Justin being in their lives while they've been while incarcerated. Mickey has been visiting every year, multiple times throughout his incarceration from day one. I have been visiting Justin at least twice a month prior to COVID for the past 5 years. I speak with him every day, and he's just a pillar, not only to my life, but also the numerous family members that are included in his family. Honestly, Justin is the strongest person that I know. To be able to accomplish and to achieve all that he's achieved in the past 17 and a half years in a seemingly hopeless position, I can't think of anyone that is stronger than he is. He's not only a pillar in his family's life, but he's also a pillar in my own family's life. My father, if I may share, just went and had a major spinal surgery. And Justin was there through that. He actually personally wanted to speak with Justin prior to that surgery and during his recovery. So he's a genuinely good person. He's selfless. He's caring. He puts everyone else above his own. And thank you, Mr. Roche, for clarifying and describing all that he has accomplished, because it's incredible. Considering the circumstances that he's found himself in. And I just hope and pray, we all do hope and pray that you see what we see in Justin today. Thank you.
Well, thank you, Ms. Garrett. We appreciate your remarks. Pastor Thompson.
Hello, how are y'all today?
Good, thank you.
It's a joy and an honor to be able to speak to this board today and to speak for my brother. My name is Patrick Packy Thompson. I pastor in Houma, Louisiana. I've been here almost 28 years in the church. I've been coming to Angola now for 11 years. Actually, Chaplain Rentz, who I know would have spoken for Justin today, except he's passed on in the last month, and he died suddenly. He was one of my mentors. He's the very reason that I am at Angola right now, ministering. I've known Brother Justin for 5 years. I started the very first Assembly of God church in any prison anywhere in the world is our church in Angola. Brother Jarrell Hardy was our original pastor. Brother Justin was the associate. God opened the door. Brother Jarrell was able to be paroled. I was able to speak for him as well. Came to my home, stayed with me some, preached at my church. Brother Justin has been pastoring the church now. We've been working with him over the last 3.5 years as the pastor there. Our Louisiana District Assemblies of God have honored Justin, gave him a certificate, gave him a plaque for the church that we've started there. One of the youngest pastors of any of the ministries in Angola. I've met several of the pastors who are working in all the different counts in Angola over the last 11 years. And I asked them about Justin, and they, all of them without exception, said he was a for real man. He was what he pretended to be out front. He was in private, that he wasn't running no game on anybody. And one of the greatest recommendations that I've ever heard from anybody, from my mentor, Jim Rentz, he said that Justin Singleton was the finest young man he's ever worked with in his life. And I'm going to tell you something, 81 years of living life and 81 years of ministry, there is not a greater word. If I could have him said that about me, I would have been very pleased. And I just want to say that as I've worked with Justin, I've watched him. My wife, myself, my daughter, and my son have all been to Angola in ministry. And we decided when we heard that there was a possibility that Justin could be have a hearing to come out, we said that he could move in at our home and live with us if that's what was necessary, because we believe in him. We believe that he's a true man of God. I don't know what he was 17.5 years ago, but I believe what he is right now is a true man who's ready to make his mark on this world. And I believe that we have a generation that needs to hear what he has to say. Young men and young women that need to know that there is hope after mistakes. Every one of us have made mistakes, not maybe as big as some others, but all of us have needed somebody to believe in us and give us hope. And I believe that Justin has proven, just listening to Brother Rochelle as he said all the things that Justin has accomplished and all the things that he's done. I believe if anybody's ever deserved a second chance, it's that man right there. And I just wanted to say, I believe in him and I stand with him. And I just want to thank y'all for allowing me to speak for him today.
Thank you, sir. We appreciate your input. We'd like to hear from the DA's office now. Mr. Taylor? I think they got to get you off of mute.
I'm muted.
You're muted, Mr. Taylor.
There you go.
There you go.
All right. Mr. Richard is going to speak on behalf of our office.
Thank you.
Good afternoon. I've tried both of these cases. I tried Justin Singleton and I tried Joseph Gilroy. I've listened to all the people speaking on his behalf. I have to commend him for all the things he's done, all his accomplishments. But having attended one of these hearings before, one of the comments that was always made was, you have to acknowledge your guilt. In his application, he does not acknowledge his guilt. He said he didn't know anything about it. Let me tell you how he was identified. The first person on the scene was a man by the name of Mr. Parity. I can't remember his first name. as Mr. Parity exited his vehicle, did not know what had happened inside the store. This is an armed robbery, by the way. Nobody's mentioned that. He observed somebody sitting in a car, and he observed someone coming out of the store wearing a do-rag. I'm doing initial investigation, and I looked at the pictures that were taken of the defendants, both of them, at the time they were booked into the St. Landry Parish Jail, and there was no do-rag. So they'd actually been arrested about 12 minutes after Mr. Parity had stopped, and they were arrested in a town called Church Point. So I called the Church Point Police Department and asked them to send me the picture of the two accused. And guess who had the do-rag on? Justin Singleton. Now, let me talk about Mr. Parity's observatory powers. He noted, one, that the car was a Chevrolet Impala, I think was what he said. I haven't looked at the file since I tried it. He said, two, it did not have a license, and it did not. And three, he said that the car had no trunk lock. Now, that's this big on that car. That car did not have a trunk lock. Other factors. He said, didn't know anything about it. Well, there was a unspent cartridge in the parking lot that was ejected from the murder weapon. So somebody walked, and we call it racking. He racked the gun. The defendant, Justin Singleton in this case, got his mother to testify that a report from somebody who lived right down the road, there was on the north side of the highway runs east and west. It's in a rural area. And the railroad track, which parallels that highway, is on the north side. The store was on the south side. And at noon, that yellow Impala turned into someone's driveway, turned around, and parked for 20 or 30 minutes on the railroad track. The gentleman who lived in that trailer said he couldn't see who it was, but there were two individuals. He described the yellow Impala, and he noted that it did not have a license plate. The defendant's mother took the stand and said it couldn't be Justin in that car because he was sitting at the table with me and we were watching some local TV program on one of the local channels. I asked her, "Do you talk to your son on a cell phone?" She said, "Well, of course not. If he's sitting in the room with me, I would not do that." We retrieved the defendant's cell phone from the jail and turned it on. And oddly enough, at the exact time she was very precise that this program that she was watching, and I can't remember the name of it, was on from, let's say, 12:30 to 1 o'clock. And guess what? There was a cell phone call from Justin Singleton's phone to his mother's phone. There's an indication that Guillory, who testified at his trial that he didn't know what was going to happen, they both did this. And that's the reason why the jury came back with a second-degree murder, because we never could establish who actually fired the shot. Now, my personal opinion was that the defendant, Singleton, was the person, because Guillory was considerably shorter. Mr. Singleton is quite tall. And the bullets, two, that went into the skull of Mr. Lejeune were at close. In fact, when they just thought there was one shot, when they did the autopsy, they discovered that actually one of the bullets had exited from the nose of Mr. Lejeune. The thing that was interesting about that autopsy was that the forensic pathologist testified that they were both parallel. They went from the back of the head and they went straight through his nose. If Mr. Guillory had fired the shot, he'd had to reach up. Mr. Singleton was such a height that he could make it But that's all we had. Now, there was a footprint on the counter where Gilroy jumped over and got the money out of the, there's a cash drawer, but a cash register, it was a cash drawer. In that place was Mrs. Lejeune. She was sleeping. It was a little house or apartment behind the store. And remember, this is in a rural area. She did not hear the shots. I can tell you that Ms. Lejeune was traumatized by this. I watched her through two trials, and she really was completely devastated. Had to close the store. Her life work. As to Gilroy, this affidavit he refers to, after 17 years, all of a sudden, an affidavit from Gilroy comes on and said, "Oh, I've lied. And I did it all." I don't know what the motivation there was, but I'll tell you what the court said. It said that based on the jurisprudence that this Louisiana Supreme Court has rendered in cases like this, that these kinds of affidavits are worthless and not to be relied on in any kind of way to determine the facts of the case. So I go back to the actual facts that were adduced at trial, both of them. And that is, I rely on the gentleman who was sitting in his house watching TV on the north side of Highway 190 and observed two individuals in that truck, in that car, for 20 or 30 minutes. What they were doing was, it was just a couple hundred yards down from the store. They were casing that store. And I rely on the film that showed that the testimony of his mother was useless and worthless and not believable. And I rely on the testimony twice of Mr. Parity and his powers of observation, because I dare say very few of us would be able to observe that the truck lock was missing. So what we have here is a person who has done an outstanding job as a prisoner. But he continues to say that I'm not guilty and I had nothing to do with it. And I find that distressing and antithetical to his conduct since he has been a prisoner. And I know that you have a letter from Mr. Timothy Savoy on behalf of the family, but I can tell you that the trauma continues to this day. And no one has been able, they couldn't even get Ms. Lejeune to come to this because it is so distressing and so traumatic. So again, I compliment Justin Singleton. I'm in awe of his accomplishments. But he hasn't done the first step. Last hearing I was here, last time I was here, when one of the board members says, the first step necessary is to acknowledge guilt.
That's the first I've heard it.
I'm sorry, not in this
First
case.
time I ever heard that.
Say
First
that
time I
again.
ever heard what you just said, that the board requires somebody to admit guilt before they'll consider it.
No. What I said was that the first step to rehabilitation is acceptance of guilt. And that was mentioned at a prior hearing that I attended or participated in. I never said that the board was requiring that. I said that and I think that's generally accepted, that acceptance of guilt, culpability, acknowledgement of guilt, and accepting responsibility for actions is necessary. And I think it's missing. And so, based on my knowledge of the facts, produced under oath on two separate occasions, and confirmed by two separate juries of the peers of this defendant, I have to say that I don't think the first step is taken. And I certainly don't think, under the circumstances in this case, that clemency at this point is deserved, earned, or necessary.
Mr. Richard, you and I will disagree under the rules of evidence, the probative value of proving that defendant's mother lied about his whereabouts at the time of the crime. I don't think that's evidence of anything. But you put great emphasis on it. But as to the affidavit that you dismissed and said you don't know what his motivation would be, why don't you just suggest to me what motivation might be if he's not telling the truth? Why would he do that?
I have no idea.
Well, guess for me. You're an experienced prosecutor. What would it be? Come on. You
Okay,
just
well,
got that
I do know that Mr. Gilroy had a young child. That's my guess, and that there's been some. Maybe he's necessarily offered some kind of compensation for that child. I don't know.
Did you just make that allegation?
It's not an allegation. You asked me to speculate. No, sir. You asked me to speculate, and I'm speculating. That's all I'm doing. You've sound's gone. I'm sorry. I didn't hear what you said.
Well, I think we probably should move on at this point. I don't know. We appreciate your input, Mr. Richard. I'll turn it over to Ms. Hogan for her closing argument.
Thank you so much, Ms. Renatza. Thank you to everyone. Mr. Roche, you did a better job summarizing Mr. Singleton's last 17 and a half years than I could possibly do. But this is truly an extraordinary case for so many reasons. Justin Singleton is an extraordinary human being by any measure of any person inside or outside the Department of Corrections. He is the best that humanity has to offer. And what's remarkable isn't just that he took advantage of every single opportunity provided by the Department of Corrections, but that he bettered himself so that he could then in turn improve the lives of his fellow man. For every skill that Justin learned, he turned around and he taught it to dozens of people. For every class that he took, he became an instructor and taught that to other people. For every official mentee he was assigned as his work with the reentry program, he was an unofficial mentor to hundreds of other individuals serving time at the Department of Corrections. He truly is the best of the best, and he is frequently selected by Angola to represent the department and the prison population in community events outside of Angola. He has sat as a panelist at the Family First Forum in Baton Rouge at the state capitol. He has sat down with former Attorney General Loretta Lynch to talk about reentry. These are just a few examples of times where Justin was selected to be the face of the entire 40,000 individuals serving time in the Department of Corrections because he is the best of the best. This case is also extraordinary because of the circumstances that brought him to prison. We are seeking mercy today based on Justin's exemplary conduct over the last 17 and a half years. That said, there is also the fact, as he put in his pardon application, that he has maintained his factual innocence of this crime for 17 and a half years. There's been evidence, there was no direct evidence linking him to being inside that store. The testimony that Mr. Richard was referring to, you know, that said that it was inconsistent at both Justin and Joseph's trial, whether who was in the store and who did the shooting. There was no forensic evidence linking Justin to it. There was no direct evidence other than, you know, there was somebody who said that they saw somebody leaving the store who was between 5'5" and 6 foot. Justin's 6'3". And since even before his conviction, there was evidence that the DA had in its possession that it withheld from defense counsel that could have led to Justin presenting his case of innocence. That was used by the trial court to grant Justin a new trial immediately following his conviction, which was later overturned on appeal. Since he's been at Angola, there's been more evidence that corroborates his version of events. And so we know that this isn't the appropriate forum to overturn a conviction. We're not asking for that. I hope that by saying that right now, I'm not changing the focus of this hearing. But, you know, the administrative code under section 203 says that an offender sentenced to life may not apply for clemency until he served 15 years of his sentence unless he has sufficient evidence which would have caused him to be found not guilty. So in some ways, the administrative code at least recognizes that in limited situations, evidence to corroborate claims of innocence may be relevant. And so I submit that this is an extraordinary case. This is an extraordinary individual, and we're asking this board to consider an extraordinary result and to commute Justin's sentence to a term of 20 years, which would enable him to be released on good time supervision, or in the alternative, to commute him to any number of years with immediate parole eligibility because of the extraordinary nature of this specific case, and because there is simply nothing, prolonged or further incarceration of Justin Singleton will make no measurable contribution to any of the reasons why we punish individuals. Thank you so much.
Thank you. Thank you, Ms. Hogan. Justin, this is your opportunity to make a statement.
Thank you, ma'am. I appreciate it. First, I want to just say that my heart has always and will always go out to the LeJeune family. No one should ever have to lose a loved one in that way. And I sincerely apologize for any unintentional role that I may have played. And I am profoundly remorseful for the events that happened on that day. Also, I just want to express how very grateful I am to be given an opportunity to just be here and to sit before this board, before Warden Vanoy and his staff, my family, friends, all of those who are watching and have supported me. And I can appreciate and understand the district attorney's passion for this case. And I do appreciate that. But unfortunately, I cannot admit to something that I did not do. You know, early on in my incarceration, I was really able to grasp the understanding that life is about choices, good choices and bad choices. But nevertheless, life is about everyday decisions that we make. And regardless of my own situation, like I wanted my life to matter. Like I didn't want my life to not mean anything to anyone. So over the years, I've tried my best and I've taken advantage of every single learning opportunity that's been afforded to me. You know, it's because of the investments that I've made in myself. It's the reason why I've been able to invest in other men who've gone out and become better fathers and family men and better friends. But I understand and I realize that it's not all about my accomplishments and it's not all about the things that I've done. I understand the most important moment in my life is this moment right here. This moment, and everything that I've done and everything that I'm continuing to do has led to this moment. And despite my circumstances and despite my claim of factual innocence, the state of Louisiana did find me guilty of the crime of second-degree murder. And I accept that. And I'm not here fighting for innocence. I am here begging for mercy. And I pray that this board would find it in your hearts to grant me the opportunity to be the man in society that I have proven to be while here in prison. And I just want you to know I really appreciate this moment. Thank you, and may God bless you.
All right, thank you.
At this time, I'd like to go into executive session.
I second the motion.
So we have a motion by Mr. Wise, second by Mr. Roche for executive session. I'd like staff to call the roll, please.
Mr. Roche,
Yes.
Mr. Marabella,
Yes.
Mr. Jones, Mr. Wise. Did he say anything?
Yes.
Ms. Renata.
Yes. So we'll be in executive session to discuss confidential matters. We'll be back momentarily. Thank you.
Thank you.
Wow. So I'm only going to come in for 30 seconds and I'm going to fast forward this executive session, which actually lasted almost 20 minutes, which if you're familiar with this stuff, that's a long time. We have seen the average, you know, these executive sessions might just go 2 or 3 minutes. When this is done, I have quite a bit to share with you, including an update with his fiance, something quite interesting. We have the appeal, and then we have something else. But do you think they're going to grant? I mean, it's quite interesting, first of all, to have Mr. Jones, a parole board member, Keith Jones, fight with the district attorney. I've seen that happen before, I think 3 or 4 times, and I imagine that it was part of what he liked to do. You know, it was interesting because Keith Jones basically asks him, well, why would, because what they're talking about is his co-defendant came out and signed an affidavit saying that he lied on the stand, that his co-defendant shot him. He said, I lied. And then, so Keith Jones goes to the DA and says, well, tell me, why do you think he would lie? And the DA says, well, I don't know. I mean, he does have a child. Maybe it was for money. And Keith Jones then blows up. Are you making that accusation?
All right,
And he's
we're
like,
back
you
in
asked
the
me.
regular
But it was
session,
quite
and,
interesting because I don't know. It was
yeah, we're
interesting.
prepared to
Neither
vote.
here
We'll
nor there.
start
Anyways,
off with
again, it was
Mr.
like 20
Roche.
minutes. We're going to fast forward that. Do you think that they're going to grant a full commutation? They have to recommend to the governor. Anyways, like I said, I'll share those information at the end.
You're on mute, Mr. Roche.
Okay. Madam Chairman, based upon an excellent educational achievements of an associate degree, BA degree, an MA degree in Christian ministry, excellent good time classes for his rehabilitation, an excellent disciplinary record, only one disciplinary write-up and 17 and a half years of incarceration, no criminal, no violent or aggressive or aggravated offenses in the 17 years. Positive remarks from Warden Benoit, outstanding support from his family and community, his display of leadership over the period of 17 years, where he serves as the president of the Empowerment Club, senior pastor of the Full Gospel Church, lead mentor in the reentry program. My vote and recommendation to the board is to commute his sentence to time served.
Thank you, Mr. Roche. Mr. Wise.
Okay, I went over this case back in 4th last night, and I looked at it today. I went over it again, and there was a trial here, a jury trial, and one of the things that he's guilty. He says he's guilty, but today I'm going to commute his sentence to 99 years, parole eligible after serving 25 years.
Thank you, Mr. Wise. Mr. Marabella?
Mr. Singleton, I have listened intently to all of the things that you have done while you have been in prison, and there's no question that you have done phenomenal things while you've been there. You were, in fact, found guilty by a jury for the charge of murder, and you were sentenced to life. You have served 17 years of that sentence. In my opinion, I'm not willing today to commute your sentence to time served. However, I am willing to commute your sentence to 99 years and make you parole eligible after serving 20 years.
And Mr. Jones?
Before I vote, Madam Chairman, I want to apologize to you, the fellow members of the board, to Mr. Richard, Mr. Taylor, to Mr. Singleton for that matter, for losing my temper before. It was not something I like to do, and I certainly did not have a ill intent in doing that. But Mr. Singleton, if this was an easy case, we wouldn't have had to take executive session and try to figure it out. And it's a case where I understand why you went to trial. I read the Court of Appeal decision, and that's the end of that. However, you are to be commended on everything you've done. My vote is to recommend to the governor that your sentence be commuted to 99 years and that you be parole eligible after serving 20 years.
Mr. Singleton, you've done, I want to congratulate you on your educational achievements. I want to thank you for the service you provide to your fellows in your own community, your fellow offenders. I too will vote favorably to commute your sentence to 99 years with parole eligibility after serving 20. So you've got a unanimous favorable vote, but the majority is that you sentence be commuted to 99 years with parole eligibility after 20. So that is the recommendation we'll make on your behalf to Governor Edwards.
Thank you. I appreciate you. Thank you very much, Board. Thank you.
Keep up the good work.
Thank
Good
you,
luck.
ma'am.
Thank you, Mr. Taylor.
Okay, Bay Granting. I think we all saw that coming. Now, I have to ask you, do you think that he was actually innocent? You know, it's interesting because the information that the DA shared, I know it kind of reminded me, is it My Cousin Vinny? You know, it's like you're in this Louisiana, there's a guy across the street that witnessed two people 100 yards away, but they trusted the guy's vision because he noticed that it was missing a lock on the trunk door. So it must have been great. But then it turns out that his co-defendant actually signs the affidavit. And then they say, well, why would he sign it? Well, maybe it was for money. And look, we have seen a lot of people claim their innocence. And I have a playlist for it. It says wrongfully convicted. There's not a lot in the playlist because not a lot of people do it, but we have seen enough do it, I should say. And it never is in your best interest to show up to a commutation hearing or a parole hearing and insist on your innocence. I think we have to take a leap of faith when we are to say, is he innocent or not? But before we take that leap of faith, let's go over the appeal so we can get some details on this. The appeal, which we'll go over that he was found guilty. Before we do, I do want to let you know that we will fast forward. At the end of going over the appeal, we will fast forward to 2022 for his parole hearing. 8/17/2022, he has a parole hearing. I have to just tell you right now, it's really not eventful. Nothing special happens. He does say again what happened with the case. They do ask him some questions, and it is interesting to see things in that sense, but it's not like anything groundbreaking. So I'm not going to, But his fiance, if you thought she might have a future in this space, she does. You'd be right because she works for the Parole Project. So I think she got hired. Yeah, she got hired January 26, 2022. And this commutation hearing happened September 21st, 2020. And his parole hearing happens October 17, 2022. So she obviously impressed them enough. And she is so passionate about this that she now works for the Parole Project. It's interesting that she has not adopted his last name. Maybe they're not yet married. Maybe she decided to keep her name. I know that people do that. I know people who have made that choice, but that just was something that I noticed. So I am mentioning it. Now, let's go over the appeal. And this is written, whoa, hello. I think we'll not do that. All right. So statement of facts. I'm quite interested to read this. Statement of facts. Keisha Lejeune and his wife owned and operated a Lejeune grocery store on Highway 190 near Opelousas. They kept the money in an assortment of 1s, 5s, and 10s in a drawer tray behind the counter. Mr. Lejeune napped in the apartment adjoining to the store until around 5 p.m. On Tuesday, March 4th, 2003, Mardi Gras Day, Miss Lejeune woke up and saw a young man walking towards her through the bathroom that connected the store to the apartment. The man said something, and Mrs. Lejeune went into the store where she saw a young woman, Amy Bullock. Mrs. Lejeune looked around, but she did not see her husband. After observing the expression on the face of the young man and woman, she began to suspect that something had happened to Mrs. Lejeune. Mrs. Bullock tried to prevent Mrs. Lejeune from going behind to the counter, but Mrs. Lejeune was able to slip away. Mrs. Lejeune made her way to the counter and saw her husband lying on the floor before Mrs. Bullock was able to pull her away. I was wondering where this was going. I said, do I have the wrong appeal? On that note, thank you, Sir Richard, for providing all the info on this. Brian St. Andre lives on a local street. I think this is the man, by the way, that the DA was talking about. That witness lives on a local street immediately off Highway 190 near Opelousas. Mr. St. Andre's home is near Lejeune's grocery, but he cannot see this. But he cannot see the store from his house unless it is wintertime when there are no leaves. Mr. St. Andre was home on March 4th, 2003. Before lunch, Mr. St. Andre noticed an older model yellowish cream Capri Classic turning around in his driveway. It went across the railroad track and remained there for 15 or 20 minutes. There were two black men in the car, with the driver appearing to sit higher in his seat than the passenger. From where the car parked, the occupants could see the entrance of Lejeune's grocery. Jason Anderson, who is the defendant's distant cousin, was studying criminal justice at Grambling in 2003. Mr. Anderson came home from college several days prior to Mardi Gras and went to the house shared by the defendant. Joseph Gilroy and Mr. Anderson's younger brother, Jean, Mr. Anderson's brother, lived there at the time. Jean. Okay, or Jean. But he was staying in Alexandria. The defendant's mother, grandmother, and aunt all lived across the street. Mr. Anderson spent Monday night at the house. He saw and spoke to the defendant and Gilroy while he was still there Tuesday morning. When Mr. Anderson left before 10 a.m. that morning, the defendant, Gilroy, was still at home. I'm trying to see. Am I following this? Defendant and Gilroy usually traveled in a Chevy Capri that Gilroy and had bought approximately 3 months prior to Mardi Gras. When Mr. Anderson was at the house on Cherry Road, the license plate was on the car. Mr. Anderson's mother, I'm having a little bit of a hard time following this. I hope you're not. There's a link to this appeal in the description if you want to read it on your own speed. Mr. Anderson's mother, Mary Agnes Gilroy Dominic, is also both the defendant Gilroy's cousin, although she feels more like an aunt to him. On March 4, 2003, Mrs. Dominic drove away from Opelousas towards Eunice, going west on Highway 190 between 4:30 p.m. and 5 p.m. Mrs. Dominic noticed the defendant and Gilroy walking along the roadside with a gas can. Mrs. Dominic picked them up and drove them to Gilroy's car, which was parked on the opposite side of the road and pointed east towards Opelousas. Once they started the car, Mrs. Dominic continued her trip to Eunice. Gilroy's car was yellow and looked like the car pictured in the state photograph. Mrs. Dominic did not remember whether the car had license plates on the back of the vehicle, but she did recall that there was a permanent license plate kind of laying over in the rear window of the vehicle. After visiting her grandmother for about an hour and a half, Mrs. Dominic returned to Opelousas. As she passed Lejeune's grocery, she noticed an unusually large number of vehicles parked outside the store. John Perotti was a frequent customer at the store. He would stop in daily on his way to or from work. Mr. Perotti, who was friendly with Lejeune's, worked until 5 p.m. that day. On his way home, Mr. Perotti stopped at Lejeune's grocery to purchase potatoes. Mr. Perotti noticed that there was a pale yellow Caprice in the parking lot. Mr. Perotti paused for a moment in his truck and noticed a black male between 5.5 to 6 feet tall, walking rapidly from the front store to the yellow car. The man was wearing a dark and light colored jacket and a do-rag on his head. This is what the DA was talking about. Mr. Perotti did not notice anyone else near the car. The man climbed into the driver's side, revved the engine twice, spun out, made a U-turn, and headed east. As the car left, Mr. Perotti noticed that there was a second black man in the vehicle. Mr. Perotti observed that the car had no license plate and no lock for the trunk. So this is what he was like, no lock for the trunk. So he was, at this point, he was in the parking lot. No, he noticed, so on his way home, he stopped at the grocery store to buy potatoes, and he saw the car. Okay. The license plate and trunk were in the condition pictured on the state's photograph. Feeling suspicious, Mr. Brody entered the store. So he wasn't far away. He was right there. But even with all of this, with his eyewitness, it doesn't mean this guy's not innocent. This guy claims that he was there, but he had no idea that a crime was about to happen, or maybe even did happen. That's his claim. He didn't even know that there was a robbery going to take place. And I guess what happened is that maybe he lied. His mother covered for him. Lies unpacked into lies, and that's, mothers will do that even if someone's innocent, which is what Keith Jones was alluding to. If you remember that, he's like, the DA is probably right about the phone having a call to him during that time of the show, but it still doesn't make him guilty. But okay, no one greeted him as he entered, which was unusual. Mr. Brody called out, but no one answered. As he approached the counter, he noticed that the mats on top were out of place. When Mr. Brody looked over the counter, he saw that Mr. Lejeune sitting on the floor in blood. Staying where he was, Mr. Brody asked if Mr. Lejeune was all right. When he did not get a response, he went to get his cellular phone from his vehicle. Mr. Brody dialed 911. Before anyone answered his phone, answered his call, he saw a patrol car driving west toward Eunice. He signaled for assistance. The police officer took the car's description and radioed the information. Mr. Brody was talking to the officer. A man and wife arrived at the store. The young lady indicated that she was a nurse and went into the store accompanied by her husband. After that evening, can you imagine, right after a crime, an eyewitness, a police officer, and a nurse is there. Later that evening, Mr. Brody identified a vehicle stopped at the Chevron station on Church Point as the car he saw at the store. Mr. Brody saw Mrs. Lejeune exit the store and leave with the nurse and her husband. Keeling Ledger lives on a road half a mile from 190. Mr. Ledger left his house on the afternoon of March 4, 2003 to walk to Legion's grocery. As he was approaching the store, Mr. Ledger noticed an older model yellow Caprice leaving the parking lot and going east. It still feels like a Uncle Vinny scene, The vehicle depicted in the state's photograph appeared to be the same one leaving the parking lot. Mr. Ledger went into the store when he was asked to leave by a woman standing behind the counter. Dr. Cameron Snyder, a forensic pathologist, the Lafayette Parish Coroner and forensic, testified to the state as an expert field of medicine with a specialty in forensic pathology. Dr. Snyder performed an autopsy on his body. Examining Mr. Snyder determined that Mr. Lejeune had been 74 inches tall. Dr. Snyder observed 2 gunshot wounds to the back right side of Mr. Lejeune's head. Who does that? Who robs a store and kills a man? This stuff is so sick. So sick. There is a lot of reasons I would think for the guy found guilty of shooting him not to admit in an affidavit that it was him, because he gives him no chance unless he knew already he wasn't going to get it overturned and he's hoping to get his sentence commuted. There was no gunshot residue to the vehicle. The gun minimum. Okay. From the position of the body, location of the bullet in the wall, in fact, the gun would be extended an arm's length away from the shooter. The dimensions of the area. Dr. Snyder testified that it is unlikely the shots were fired from behind the counter. The gun would have necessarily have been about 5 feet to 7 inches from the ground when it was fired. 5 feet 7 inches. So here's where they're talking about that it was his height. It would have been him and not his co-defendant. Miss Balish is a registered nurse at the bachelor's degree. On March 4, 2003, Miss Balish, who was living in the grandmother Eunice, traveled for Jared, who would later marry to visit. I'm skipping ahead now. There are 32 pages. I'm not going to go through all 32. Let's see what happened here with the arrest. So, as patrolman Valier was getting off duty at 5 p.m. on March 4, 2003, he received a bolo for 2 black males in an old Chevy vehicle that had been involved in an armed robbery. Patrolman Valer drove to an area where he could observe traffic coming from the area of the armed robbery. After a while, Patrolman Valer noticed a dirty beige rattan old Chevy occupied by two black males. Patrolman Valer followed the vehicle into the Church Point limits. Once in the Church Point, the vehicle stopped at the Chevron station. Patrolman Valer did not approach the vehicle. Instead, he radioed in and waited for backup. Patrolman Valer had noted that the license plate was in the back window, which was not the correct plate. Patrolman Valer watched the passengers of the car attempt to reattach the license plate to its proper location while he waited for assistance. When backup arrived, Patrolman Valer approached the driver while the other officers contacted the passenger. Patrolman Valer identified the defendant as driver of the car. So the patrolman is saying that he's the driver of the car. Noting the defendant had been wearing braids in his hair and a do-rag, which the defendant later removed. So this is what the DA is talking about. This is not looking good for him, right? He's the driver. It's wearing the, but I guess actually the guy who would pull the trigger could have easily been the passenger, theoretically speaking, right? Sergeant LaFouse assisted Patrolman Valer in determining the two armed robbery suspects. When they arrived at the Chevron station, Sergeant LaFouse noticed that the vehicle parked at the gas pump and a black male exiting the store and going towards the rear of the car. The man did not have a hat on of any kind. However, the man behind the wheel had on either a stocking or a knit cap. Sergeant LaFosse first assisted in contacting the man in the rear of the vehicle before going to the driver's side of the car. Contacting the man in the rear of the vehicle, it's driver's side of the officer. Venable placed the license plate in front of the passenger. Officer Venable had also taken money from the man in the rear of the vehicle and placed it in front of the passenger. Sergeant LaFosse discovered the gun, which was partially revealed because of the center armrest was not completely closed, however, was left where it was and he did not touch it. So, yeah, gosh, this is taking a while. I know we're already deep into this and we've been here a long time. They talk about the gun, they talk about the money, what they did this all for $68 and $9. Are you kidding me? Psycho. We talk about the different height, do-rag. That's pretty much it. Investigators obtained a do-rag for the defendant and a pair of Air Jordan sneakers from Gilroy. Gilroy's sneakers had a spot of blood on the toe of the left shoe that tested positive, belonging to Miss Lejeune. Gilroy's shoe also matched footprints at the crime scene. The bullet fragment removed from Miss Lejeune's head and the bullet removed from the pegboard in the store were fired from the handgun found in Gilroy's car. Additionally, the unfired bullet found in the parking lot had also been ejected from the pistol. Well, that's not Singleton. That, you know. That's not the defendant. So, I mean, kind of points. So I guess the question just comes down to the fact is, did he know that there was going to be a crime around? It doesn't mean that he had to shoot. It seemed though that the detective was saying that he did shoot because of the height and because of the do-rag and whatever. DNA. Defendant additionally alleges that the state failed to introduce evidence showing plan or agreement by the defendant. There was no witnesses to the actual crime, that the verdict is called into doubt because the co-defendant was the only one with DNA linked to the crime scene. Well, there you go. If the co-defendant's the only one with DNA, I wonder why the Innocence Project didn't pick this up. That the circumstantial evidence presented by the state was inadequate for a conviction because it did not exclude every reasonable hypothesis of innocence, and that even though he was charged in principle, the state failed to prove a specific intent to kill. So he was charged the principle, but they didn't prove intent to kill. So really it actually comes down to, I don't know why the DA, I felt like the DA was saying that he thought he shot. That's what I thought I heard today. And that's not even what it says in the appeal. Then the question is, did he know? Did he know? Look, I'll tell you this. I'm just going to stop it here. It'll be going long enough. And then we're going to watch the parole hearing. Ultimately, we have to take a leap of faith because we just don't know. And I'm going to take the leap of faith that he is innocent, that he didn't know. And if I am wrong, I'm still okay with that, because he clearly has done the most that he possibly could do in prison. I don't believe he fired the shot. And if there's anyone that should get a chance, it would be someone who has done everything they possibly could in prison. This is just one of the cases where I'm definitely for them granting. Now the question is, do I think he's innocent? I would take the leap of faith to say yes. There's just not enough there that I would feel that I could see a jury saying that there's not enough. How can you know for certain that he knew that a crime was going to take place? People do, that's so. That's just my opinion, and it's always nice to see old school DAs show up to plead their case and whatnot, but man, I wish they would show up for when it has to do with a child. We just don't see that. We don't see that. And the bottom line is there are, I don't know, what is it, 1 or 2% of people who are locked up are actually innocent. So if there's going to be any case, like, might as well be this one. That's just my opinion. Love to hear yours in the comment section. And I'll tell you, if I was wrongfully locked up for something, I would be bitter as hell. And you don't see that bitterness. Anyways, let's go watch the parole.
Camera so we can see Mr. Singleton, please. Here he is. All right, good morning.
Good morning.
Mr. Singleton, for the record, sir, would you introduce yourself, tell us your name and your DOC number?
Yes, ma'am. My name is Justin Singleton, DOC number 509796.
And you are represented by counsel this morning. Counsel, would you introduce yourself?
Good morning, Ms. Renata. Jane Hogan on behalf of Mr. Singleton. I will make a statement at the end of the hearing with the committee's approval.
All right, thank you. And so, Mr. Singleton, you're kind of familiar with the process. You had a pardon hearing in September of 2020, I believe. And
yes, ma'am.
See the favorable recommendation, and that recommendation was signed by the governor. So you are currently serving a 99-year sentence for a second-degree murder out of St. Landry Parish. You do have a parole eligibility date, which is March 5th, 2023. Just your good time dates, November 4th, 2085. You have a full-term date in March of 2102. Your sentence was commuted from life to 99 years with parole eligibility after having served 20 years. Is that information correct?
Yes, ma'am.
All right. Let me just acknowledge those who are here speaking on your behalf. Andrew Hundley with the Parole Project and fiancee Kelly Garrett. And we'll call on them at the appropriate time for their comments. Your case was assigned to Mr. Freeman, so please answer his question.
Good morning, Mr. Singleton.
Good morning, sir.
How old are you, Mr. Singleton?
43 years of age.
Okay, and how long have you been incarcerated on this charge?
19 years and 5 months.
All right. It's like your educational level is very high. Do you have a master's degree?
Yes, sir.
Okay, and you've earned over 725 days of credit, which is really, really great. Tell me a little bit about what happened on the day of this offense. What went on? What was going on?
Yes, sir. Yes, sir. So my co-defendant and I were on our way to Lafayette, Louisiana on Mardi Gras Day, March 4th, 2003. We stopped by a local corner store. He went in the store. I remained in the vehicle. He came out a few minutes later and we left. And then about 30 to 45 minutes, we were both apprehended and charged with the crime of first-degree murder and armed robbery. Eventually, we were both tried separately, in which I was convicted of the crime of second-degree murder, and I have been in custody since the day of my arrest.
Okay. And your co-defendant wrote an affidavit stating that you had no idea what was going on?
Yes, sir.
Just tell me, why should I believe that you had no idea what was going on? Did he come out with any money? Did he act differently? I mean, were you under the influence?
No, sir. At the time the crime was committed, I did not know that he was going to commit a crime, nor that he did commit a crime. And he did not write an affidavit right away. It was sometime throughout his incarceration that he had an experience, according to his own words, and he felt that was something that he needed to do, not necessarily for me, but for himself and for the family of the victim.
Well, what would you say to the family of the victims if you had a chance to say something?
Yes, I would first say that my heart has always and will always go out to the Lejeune family. And I sincerely apologize for any unintentional role that I may have fulfilled. And I am profoundly remorseful for the sequence of events that took place on that day. I cannot imagine how that day has changed the rest of their lives. And I pray for them every day.
Okay. You know, you had some comments. Law enforcement is opposed. Your family is unopposed, your mother. And the victim, of course, is adamantly opposed to this. What is going to be your transition plan if you are to get out?
Yes, sir. So upon release, I had been afforded an opportunity to participate in the Louisiana Parole Project's transitional programming, in which their wraparound services, I believe, will make for an easier transition into mainstream society. I also have been provided residence by my aunt, who has provided a fully furnished guest home that is located directly behind her home in Baton Rouge, Louisiana. She has been like a second mother to me my entire life, and so I'm very appreciative of the residential opportunity that she has decided to accommodate me with. And my employment will be with VOTE, Voice of the Experience, as a community organizer, helping to continue bridging the gap between the community of the ex-offenders and the public.
I see you have tons of certificates. I'm not going to go into reading them all. Looks like you're very active in the JCs. What did you get out of the JCs?
Well, JCs, when I participated in the program, it's a self-help organization that provides self-help classes and rehabilitative classes to the inmate population. And they do a variety of different classes, whether that be public speaking, leadership, family dynamics. And I enjoyed it thoroughly. So I have also been facilitating those classes for well over a decade now. So just being able to give guys in this community the same opportunities that those classes have given me.
Okay. Out of all the classes you've taken since you've been at Angola, which one or which group or which class have you gotten the most out of?
I would have to say that my work with the reentry court program has been the most rewarding for me. Not only have I learned a trade and a life skill that will no doubt aid me in achieving an even greater degree of success in the future, but I've also been able to witness lives change from some of the investments that I've made. And so for me, that's been the greatest reward, just being able to invest in those individuals who still have a lot of life left to live. As you know, the men in our program will someday, for the most part, walk the streets of society again. And so the lives that they go on to live will be a direct reflection of the knowledge, the training, and the love that we were able to give them during their time here. And so it's just been a privilege for me to be able to invest in men who can go out and invest in our communities.
Well, that's a great program. That's one of the best ones we've ever come up with. Correction. I thank you for your participation. Your risk needs is low. You hadn't had a write-up since 2010. How many write-ups have you had since you've been in prison?
That's the only one, sir.
That one. Well, that's a great disciplinary record. Warden Ambo, is there anything you'd like to add on Mr. Singleton?
Yes, sir. I can tell you that he's been one of the most prominent figures in our reentry court. He is the safety coordinator for our reentry mentors, making sure that everything that's done in the reentry court such as automotive, and everything is done in the safest manner possible. He has a plethora of certificates that he went through, and I just say that he's one of our model offenders here.
And thank you, Warden Ambrose. I have no further. Ms. Renata.
All right. Let's hear from those who are here in support. Mr. Hunley, we'd like to hear from the Parole Project.
Thank you, Andrew Hunley with Louisiana Parole Project, here today to confirm that if Justin's granted parole, he would have a place in our reentry program. We are really excited about the possibility for Justin to be a part of our program, not just as a participant, but based on Justin's experience, his reputation with staff and other prisoners at Angola. You know, he's built a solid reputation for himself with his work, and we feel firmly that he's the type of person that if he came home, he would continue to have an impact on people in the community who are coming home and continuing his life as a mentor. If he didn't have that job already with Parole Project, he's the type of person Parole Project would offer employment to. Not much more to offer than the board's already aware that he has one of the most impressive resumes of anyone that this board has probably seen, and the work that he's done at Angola to better himself and to better those in his community is certainly sincere and true, and we look forward to him continuing to do that if he's released on parole. Thank you.
And I think we have the pastor with us this morning who'd like to speak.
Hello, my name is Pastor Patrick Thompson. I pastor Houma, Louisiana. I've been working with Angola for about 11 years with Main Prison and DCount. It's been my privilege to work with Justin. He is such a good brother. We have watched him over the last several years. And I've talked to inmate pastors in Angola about him as he was getting ready to become the pastor of a church that we have sponsored through the Assemblies of God. It's the only Assembly of God church that's recognized in any prison anywhere in the world is the one where Justin pastors. All of the pastors, all of the ministers in Angola have great respect for him, and so do I. Matter of fact, if he didn't have a place to go when he was released, my wife and I have already talked, and he could come stay with us. He's a true man of God. He has made such a difference in the lives of the men he has mentored in there. It's been obvious through all the things that have been said. He is an example of what the prison intended to do, and I think that releasing him would be a benefit to society. I do not think that he would be a detriment to society, but he's a great benefit, and it would be a pleasure for me to have him in my pulpit preaching on a Sunday morning. Thank you.
Thank you so much. And Ms. Garrett, we'd like to hear from you.
Good morning, members of the board. Thank you for the opportunity to allow us to speak. I'm here today with many of Justin's family members, including his mother, along with my own family members, my mother and my father, and also my daughter, as well as cousins and friends of Justin. And I want to recognize the many supporters that we have watching as well. We are here collectively in support of this hearing today. 2 decades ago, Justin entered prison as a student. Now he's an instructor, a mentor to other students. He began the journey simply going to church, where now he is leading and pastoring that same church. He didn't stop at just obtaining an undergraduate degree. He continued on to obtain a master's degree and many other certifications, bettering himself with a sincere interest in helping others. He's never allowed the situation to define him or alter his growth. He admirably utilized every opportunity offered while maintaining a humble, positive outlook on his life. I've personally known and been on this journey with Justin for the past 7 years. And throughout this time, I've seen him continually grow and mature into the man he is today. I visit him on every allowable chance that there is. We've both grown and matured together, being accountable to one another and jointly making decisions. He is very much intertwined in my life as well as my family's. Already he's referred to as a son-in-law and a bonus dad. Along with family, extended family, and friends, we are here collectively committing to assisting Justin obtain his full potential. He is loved by many who are prepared to provide their encouragement and support needed if granted today. I personally understand and have experience with assisting formerly incarcerated individuals transition and rebuild their lives, witnessing firsthand the power of redemption and a second chance. I don't think I speak for myself when I say that I am extremely proud of who Justin was, is, and will continue to become. I'm proud to be on this journey with him and will continue supporting him along the way. Thank you so much for this opportunity, and we sincerely hope that you see the potential of what we've always seen in Justin today.
All right, thank you. Thank you all. We have no one here speaking in opposition, so I'm going to ask Justin, is there a statement you'd like to make before I turn it over to Ms. Hogan?
Yes, ma'am. Thank you. Again, just want to express that my heart goes out to the family and we'll continue to pray for them. And just want to also express how very grateful I am to be given this opportunity to sit before the board today, before my friends, families, and loved ones, and all of those who have supported me. And I just pray that you all would find it in your heart to not just give me another opportunity, but to just show me mercy today, that I may have an opportunity to just be a part of my family's lives again. So I thank you for your work, and I thank you for this chance.
All right, thank you. Ms. Hogan?
Thank you, Ms. Renata. Just to corroborate what's already been said this morning, it's an honor to represent Justin. He has not spent any moment idle for the past 19 and a half years, as evident by his 80 certificate, 3 higher education degrees, multiple vocational trades, and his work with the reentry court, as well as his work with his faith-based community. I think it's also really indicative that when he was granted clemency in September of 2020, he didn't then get comfortable and sort of slack off with the work that he's been doing. In the last 2 years, Justin obtained 4 new safety certifications. Through his work as the safety coordinator with the reentry program, they've celebrated a year without any incident over all of the vocational schools that they have. Justin makes sure that the mentors have all of the protocols and the tools they need to be to operate safely amongst the prison. It's a role that he created for the reentry court. He saw a need, he filled that need. That's kind of the theme of Justin's last 19 years and beyond. Justin's also one of 2 offender advisors to the secretary from Angola, and he completed new programs also in the last 2 years. And because COVID stopped in-person congregational worship services, Justin began a yard ministry on the West Yard. They started with 6 people and they grew to about 170 people every Sunday worshiping together safely during COVID. So we could go on and on and on. Justin Singleton is going to improve any community that he's a part of. He has demonstrated that over the last 2 decades, and any community that he's in the future is going to be so lucky to have him. So we would ask this board to grant his release under any conditions that are deemed appropriate. Thank you.
The panel is prepared to vote. Mr. Freeman?
Justin, you are definitely one of the best interviews I've ever had. You have definitely taken advantage of your time while you've been in DOC to make yourself a better person. So my vote today is going to be to grant your parole with the condition that you have no contact whatsoever with the victim's family. You do not return to St. Landry's Parish without permission, and that you speak with that you to let them know. I mean, in your case, you know, maybe you didn't know what was going on, but you was with the wrong person, and look what it got you. I mean, you lost 20 years of your life. So, I mean, you know, let the youth know if you got to choose who you hang around with. I mean, a lot of people say you can't choose your family, but you can't choose your friends, and that's true. And so, once again, I vote to grant.
Thank you, sir.
Jackson? All right, Mr. Yoder, I've listened to you, I've reviewed your file, you've got an outstanding proven record, you're a model inmate. You've not only done a lot of work for you for yourself, you've also helped others. So my vote today to be to grant your parole to be the parole process.
Thank you, ma'am.
And Justin, I do agree, you have you work hard, and I appreciate it. I want to thank you for that. So my vote today also is to grant, and I think we mentioned the opposition that was expressed by the St. Landry's District Attorney's Office. So the special condition, as Mr. Freeman has reiterated, do not return to St. Landry Parish, along with the other conditions that he's given. You can grant it parole.
Thank you so much. I appreciate you guys. Thank you.
Praise God. Yes.
Praise God. You know what? Again, I'm on the bandwagon that he was innocent. I'm gonna make that leap of faith, and I am happy that he is out. I think that he is very deserving of it. I think he checks all the boxes. And hey, even the DA didn't show up at this point. But I have nothing else to add. I did search him up to see if he's been in any trouble. There was a little bit of a scare, and it showed a recent arrest just a few months ago for possession, and he had the same name and everything, but wrong person. The person was in the 20s who that was arrest was for. I can't see where he is. It does not appear that he's working with the Parole Project. I have no trace of him existing since this parole hearing, and I would just say that that's probably a good thing. And thank you, Sir Richard, for the information. I do hope it works out. I do hope that we don't hear from him again. And with that, I'll let you go.
And I find that distressing and antithetical to his conduct since he has been a prisoner. And I know that you have a letter from Mr. Timothy Savoy on behalf of the family. But I can tell you that the trauma continues to this day. And no one has been able, they couldn't even get Ms. Jean to come to this because it is so distressing and so traumatic. So again, I compliment Justin Singleton. I'm in awe of his accomplishments. He hasn't done the first step. Last hearing I was here, last time I was here, when one of the board members says, the first step necessary is to acknowledge guilt.
That's the first I've heard it.
I'm sorry, not in this
First
case.
time I ever heard that.